Hey, everybody. Welcome. Welcome back. It's good to be back. It's been a long time since I've gone live. And I'm currently on the southernmost city on the planet. Quite a place to be. Thought it might be kind of a cool place to stream from down here in Puerto Williams, Chile. I'm getting ready to go on a fairly extended hiking trek down here. It's going to be about a 5-day thing. And oh, I just checked the weather and it's beautiful, beautiful out there right now today. In fact, I'll share you a nice little picture of what things look like right here outside my hotel room. It's pretty lovely. See if I make that a little bigger. That is the Beagle Channel that you're looking at there. That is named after the, of course, second expedition of the Beagle, which was captained by Captain Fitzroy, and on which Charles Darwin did his pretty notorious trip, notorious journey. And yeah, pretty cool place all in all. So anyway, I apologize for the delay. It's been a little bit of an undertaking getting down here. I had a big delay on my flight today, and so I'm kind of just getting settled in. This is not going to be, of course, up to my, normal production standards. As you can see, I'm in a hotel room. It's going to get dark, like while I'm doing this, and there's really no lights here. I mean, the lights that I have are on, so we might end up just sitting here, looking at me in the dark. And the sound is not ideal, everything. Also, there's no chair or anything in this room, so I have my laptop up on a pile of pillows here. And so it might shake around a little bit. But it's just all part of the fun of this one. So I wanted to have this live stream because we had a big hearing in the Kohberger case, and it's been already a week since it happened. And I know a lot of you folks have been able to watch it already, and I haven't. I'm way behind, so I haven't seen any of this yet. Here's the general background. If you're new to this at all, this is going to be hearing on multiple motions to suppress that were filed by Bryan Kohberger's team. And motions to suppress generally are arguing that there's been some type of violation of rights that causes whatever evidence was obtained to be fruit of the poisonous tree. And so these motions to suppress are targeted at a variety of different search warrants that were issued in the case. And there's a whole bunch of different arguments that have been made. Some of them overlap. Some of them are specific to certain motions. And so among the things that have been kind of hinted at in these motions, but that we just don't get to know about because the court is sealing a substantial amount of the factual information that supports these motions at this point in time. We don't necessarily know the details of what the claim is, but we know the general legal claim that's being made. And so the ones that are particularly interesting here, from my perspective, are claims that number one, there's a request for a Franks hearing. And so this is an argument that the state has either misrepresented facts in a search warrant, or it has omitted facts, material facts in a search warrant. And so basically it changes the calculation about whether there is a probable cause or not. So it's essentially an allegation of some kind of law enforcement misconduct, shenanigans, if you will, with the evidence and the allegations. There are arguments about the investigative genetic genealogy that's been performed in this case. There's been a hint at the argument that I have suggested from day one. I just thought this might be an issue about the garbage collection from Bryan Kohberger's parents' home in Pennsylvania. And this garbage collection was done without a warrant. and it was done for purposes of trying to get a sample to compare to the DNA sample that had been recovered from the button of the knife sheath at the murder scene. The reason why we had suspected this was a problem from day one is because when these warrants first started being made public, the one for the WSU properties, his apartment, his offices, and things like that, it had this disclaimer in it that I have never seen, I haven't seen anybody that I've looked at in the commentary that's ever seen any type of disclaimer like this. And the prosecutor has essentially said in it, this DNA evidence, we're telling you we have it in the interest of full disclosure, but we don't want you to actually rely on it in case there's a problem with it. So we want you to make a probable cause determination without relying on this DNA evidence. Extremely unusual, and it's such a red flag that the prosecutor, it has to be pretty bad for the prosecutor to be concerned that there could be something that wrong with it, because it's normal to anticipate that there's going to be challenges to different aspects of the investigation and stuff like that. But to specifically ask them not to consider DNA evidence, yeah, that's a big red flag in the case. So there are hints that that type of argument is potentially being forwarded here. Arguments that the search warrants are overbroad. These are ones that, in some respects, with respect to some of the warrants, I think that may be a fairly strong argument. I believe it's some of the Apple warrants in particular, that's like for all of his data pretty much ever about everything. So there's really no limitation on what the police were going to be allowed to seize and look through and rely on, which is not consistent with the general requirement that warrants need to be narrowly tailored to the particular evidence that is suspected to be present, that would, tend to inculpate the defendant in criminal activity. So that's kind of the broad overview of what we're expecting to see in this hearing here. Now, again, a lot of you guys, you may have already seen this. I'm coming in cold. I've seen a little bit of the commentary, but I really am not sure what to expect here. So I'm really looking forward to this. My plan for this is the hearing has been broken up into 2 days, or two sections, two sessions. And so to not basically be up all night, I'm going to go ahead and watch one session today and give you my reactions and feedback and stuff. And then I'll go ahead and live stream tomorrow as well to watch the second part. And then we'll be all up to speed on everything. Last thing I'll add is just if you do want some more detail about the background of these motions, I did do a video about that. So go ahead and go into the Kohberger playlist on my channel, and you can search through and find that. And hopefully that will fill you in a little bit more on some of the legal posture of where you are. So guys, with that, I'm going to go ahead and get us started here. Let me go ahead and got the video queued up. Oh, also, I'm going to watch it. I'm going to try to watch it at 1 1/4 speed, just in the hopes that that will be good for everybody. If it's too fast, I will go ahead and put it back to normal, but usually it's pretty good. So fingers crossed. Let's get it going.
Are we ready to go live? All right, go ahead. Let me know when we're ready, Sandra. All right. We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming for the record. The defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Franks motions filed by the defense. That will include the Franks hearing that was held on the IGG issue as well as the defense's proffer as to the rest of the Franks issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Franks next.
I did not. I apologize.
Uh-oh.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Franks items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by 4th Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All 3 of those stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed. Your Honor, I'm
going to go ahead and pause that here. So I'm skeptical kind of off the bat that there's a warrant needed for each one of these stages. And the reason why is because these particular stages, I don't really see how they implicate the defendant's privacy interests. Maybe she'll get into this a little bit further, but the way that I see it is that the acquisition of the DNA from the knife sheath at the scene of the crime, I mean, that's the seizure. But the whole issue is whether he would have a reasonable expectation of privacy in DNA that's on a knife sheath at a crime scene. And I mean, I appreciate she's saying this is based on the 4th Amendment and the due process, but the problem is that generally police are free to obtain, develop, the evidence that's present at the crime scene, usually because it's considered abandoned or just because, it's out there in a place where people were able to find it. So, you didn't secure it. There isn't necessarily a reasonable expectation of privacy in that. So I'm not really seeing why there would be a specific expectation of privacy in Othram having it as opposed to the Idaho lab. Or same thing with the FBI. I'm not really following this line of reasoning. Now the trash pull, yeah, we're on the same page about that. Going in and getting somebody's trash, that's a different acquisition. That's not something that's left at the crime scene. So hopefully she will develop that argument a little bit more. Because I'm skeptical so far.
The purposes of the 4th Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where This identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for your honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI...
I'm going to pause that for just a second. That's potentially a problem, but it's really potentially a problem that I see only if the state is going to try to offer the IGG, and they've kind of already highlighted that they aren't going to do that. They want to just bring in the final results. They don't want to bring in the process itself. If they were going to bring in the IGG process, then they have to tell you who, you know, it's hearsay. Basically, there's I'm not going to remember the names of the cases off the top of my head, but there's a Supreme Court case law that deals with the testimony of analysts and how you can't have one analyst testify to the conclusions of another analyst because that's hearsay and that's depriving you of the right of confrontation against the person that did the actual testing and formed the actual opinion. So if they were going to introduce the IGG, then there's no question the feds, you know, redacting this information and not providing it, that would be a problem. But if the state isn't going to introduce it, is it an issue of a constitutional magnitude for them to know who performed the work? I don't know that it is. It's a discovery. It's a discovery question. Again, let's see where she goes with this.
gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't.
These are getting to, sounds like more like evidentiary problems, foundational problems, authentication problems, basic scientific methodology problems. And so those might be grounds for, you know, alternative grounds, not for suppression. Suppression tends to be a term of art for these types of constitutional problems, but for exclusion, for keeping it out because it doesn't meet the standards of the evidentiary rules. So generally, if you're going to present some type of scientific evidence or, you know, testimony, you have to show it's based on a reliable methodology. It's going to produce, you know, accurate, reliable, reproducible results. Idaho, I'm pretty sure doesn't follow Fry. I once again don't remember exactly off the top of my head. They don't follow Fry. They don't follow Daubert. It's kind of their own. It's kind of their own standard. That's a little bit closer to Daubert, I think, than Fry. Fry's standard is do experts in this area generally accept it? Daubert's standard is the method reliable? Is it scientifically reliable? So they don't really specifically follow either of those, but it's kind of maybe a little bit in the middle. If they don't know how the profile was produced, then that seems to be a little bit of a problem in terms of establishing that it's a valid methodology. And this is still such a novel technology that I really don't know how much of this stuff has been litigated in courts around the country. Courts are notoriously slow at adapting to scientific changes. This is a field that is developing extremely rapidly. Courts are only just now kind of starting to grapple with the idea of using it at all, let alone the specific techniques for how it's being done. So I appreciate what she's saying here, and I think these are going to be important points, but I'm not sure that they really go to suppression. I think they might be previewing a different type of argument for exclusion that would be something we might see in a motion in limine. We'll see.
We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file.
Okay, this is an extremely important question because this is going to the privacy interest. This is going to the standing issue. And so the problem that has always been there with the investigative genetic genealogy is the fact that they're relying on these third-party databases. The whole idea is that they've looked in CODIS, right, the federal depository for DNA profiles. They haven't been able to find a match. So your own DNA isn't available in that match. So what they do then is they go into these databases, these private databases that people are using for their own ancestry research, their own health information, and things like that. They are getting related profiles, and they're using those related profiles to build out basically a family tree to try to figure out where you would be on that tree based on the degree of relationship between the sample that they have and the samples that they're able to find in the database. So the problem that has always been out there with the IgG technology in terms of challenging it is that you don't get to assert a violation of somebody else's rights. And so let's say, as we heard from one of the earlier hearings in this case, the motion to compel, when they were trying to get this information about the IgG in the first place, we heard testimony that the FBI routinely breaks the rules for how the restrictions that these databases have put on law enforcement's ability to access profiles. People now generally have the option to opt out of being involved in law enforcement searches, but law enforcement has found ways around that. They've also found ways to be able to conduct searches that basically violate the terms of service because the organization will have the database will have specific rules for law enforcement searches or specific portals that law enforcement are supposed to work through. And law enforcement has figured out ways to basically work around that and act as if they're like just an ordinary consumer and not be subject to those law enforcement restrictions. So these would be, potentially violations of the rights of the people in the database whose extremely personal, private, very detailed genetic information is being seized without their consent and without a warrant. But standing means if it's somebody else's rights that are being violated, you don't get to raise that. You don't get to argue that I'm entitled to relief because you went and seized somebody else's DNA without their permission. It has to be a violation of your own interests. So where these arguments around IgG have typically been made to try to deal with that is an argument that there's basically a privacy interest that everybody has in the shared portions of the genetic code. Well over 99% of everybody's DNA is the same. I mean, like more than 99% of our DNA is the same as with chimpanzees, and it's pretty high even for other primates. So the typical conventional identification, DNA identification that has historically been used, this STR identification, it's very limited in the information it presents. and it's individualized. The whole reason why why this technology was developed for identification is because these combinations of SDR profiles of just essentially certain codes at certain points on the gene, they are extremely individualized. They're very variable between generations. And so your combination of those particular points, it's like 20 now, I think that they use, or 21 points on the code. Very, very tiny amount of genetic information that also doesn't tell them anything about anything else about you, your race, your hair color, your health conditions, nothing. That's individualized. When they start to get into the SNP profiles, you're now looking at a much, much, much larger piece of the human genome, and you are looking at those details that give private, personal information about how that gene is, going to express what sort of proteins it's gonna code and what effect that's gonna have in terms of producing a human organism. So this is where the argument has really focused, is arguing, look, because of the nature of this technology, the nature of how much private information is being exposed, there should be a recognized privacy interest in these shared components of the DNA. And so therefore, if you go and seize this information from a genetic database and use that to basically look at those, because it's the common points that they look at to be able to ascertain how closely related is this profile that's in the database to the one that I'm trying to identify. That's what the expectation of privacy should be in. That has been rejected so far by, as far as I know, every court that's looked at it. It came up in Washington State 1 or 2 years ago now, and our courts rejected that. Said nope, there's a standing problem. No privacy interest in shared DNA, shared parts of the genome. So basically, you're out of luck. They get to do this, and if they break the rules, too bad, so sad. No remedy for criminal defendants. That's kind of the world and the posture that we're in. So that's why this is such an extremely important question that Judge Hippler is asking, because if in fact it was Bryan Kohberger's own DNA in the database, then we wouldn't have the standing problem. It would be a violation of his own privacy. It would be his own genetic information that potentially was, unlawfully seized, or, shenanigans with it, or just even obtained without a warrant, period. So, yeah, really, really important question from Judge Hippler there.
I don't have,
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife sheet.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't turn out a name and say this is your
I have a
suspect.
privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
Not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
This is like the key question right here. This is the key question. She better have an answer for this. This is like square one. This needs to be addressed. How do we get past the standing problem?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, It is, Judge, but you're assuming that the DNA was taken lawfully, and our position,
I agree that part was, is an assumption. In my hypothetical, I
She's,
said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA?
yeah, she doesn't have an answer. This isn't great. This is where you really got to get into the policy and the implications of what it means to not recognize that type of a privacy interest, because you're basically at this point, uh, we're in the panopticon, okay? My my Foucault folks out there, that's the panopticon. You don't even have the ability to opt out anymore if the government can simply access everything that it needs to know about you without ever going to you at all, by just going to your relatives. It's just sort of defeating the purpose of having any type of distinction, because so much of the genetic code is shared. So much of it's shared. And so this may not be too much of a concern for people right now, where we're just talking about, identifying a criminal. But when they start to use this technology, and believe me, they will, there's always creep in how these doors get opened. There's going to be creep, because they're going to start to interpret these profiles, and they're going to start to use these profiles to create predictions, to be able to look at the characteristics that these profiles are coding for. So they're going to be able to build a suspect profile. This is going to be a brown-haired person, so tall, such weight, yada yada, these degrees of relationship. And maybe I'm cynical, maybe I've been doing this job a little bit too long, but it gives me a lot of concern that that type of thing is going to give police probable cause to go looking at a lot of different people who might fit that profile. A lot of different people might fit that profile. Yeah, that's the type of reason why we need to be concerned about the creep that that this potential technology can open up. But she doesn't seem to have an answer, and so she's avoiding the question, and that's not good. That's not good, because this is a real basic issue with this type of legal problem. And so I don't like that she isn't addressing it head on.
Simply because I might share some genetic information with them because they are distantly related to me.
well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant. that
He
this was
knows
done
that.
outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that
Mhm.
if hypothetically
right.
here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that.
Yeah, he's right about that. There's nothing that says if you leave your DNA at a crime scene, the police, it's not totally fair game. I mean, that's evidence. That's the nature of evidence. You drop blood at a crime scene, it's fair game. You leave a fingerprint at the crime scene, it's fair game. You leave hair, fibers, trace material at a crime scene, it's fair game. Not going well so far.
And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Hmm.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different
So
search.
I'm going now to
Yes. Explain why it's a different search and why that matters. How is it different? How's the SNP different from the STR? Why are the privacy interests so different? He's right. The law's not on her side here. There's no case she can point to say, you know, this court over here reasoned it this way. They've all held against her. So you just gotta have a good explanation for why those differences matter.
I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Oh, shit.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
Okay.
Our first point is it was an illegal search. And this is if
The search,
the
which
court's
search?
assumption,
Which search? It was illegal.
well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super that happen when there's a portion of the DNA and it's searched to create a snip. And then when that doesn't do anything, the FBI says, oh, here we go. Let's search the snip ourselves. That's what I'm talking about.
She's talking about the processes that they use on the DNA that they got at the crime scene, which is where he's hung up. And he's hung up because there isn't really any case law saying they can't do whatever they want at the crime with evidence left at the crime scene. They can do whatever they want with it. They could do stuff that's not going to be admissible as evidence, and that's fine. It wouldn't meet the standards for admissibility. They wouldn't be able to use it at trial, but it doesn't mean they can't do it. They can do it. They just maybe can't use it. I feel like she's got stuff here, like this pointing that the abandonment theory means knowingly and intentionally leaving something. That's really important because touch DNA, trace DNA is not that. Nobody is knowingly and intentionally leaving trace DNA places. Unless they're, the court's going to start to recognize some type of principle that, because everybody knows about trace DNA or something like that, which is not true. People don't know about trace DNA. They don't know about transferability. That's why it was such a shock to be over in Delphi when the state's own experts, the state's own forensics people are acting like, trace DNA all over the girls that doesn't match Richard Allen is no big deal at all, because that's just normal. Stuff is everywhere in the environment, transfers all the time. Yeah, that's true, but the state's experts never freaking admit that. So, man, what a double standard. But that's I think where we'd have to get is some kind of imputed knowledge that because people know, we're all sort of like Pigpen and the Peanuts when it comes to our DNA. You just sort of leave a cloud of it wherever you go. We walk around in this like miasma of our own particles. This is going to like creep out poor Jeff, my my somewhat cootie phobic husband. But that's how it is. Some people will shed more DNA than others, but every single one of us sheds skin cells throughout the day. We have, saliva that's aerosolized in our breath around us. Yeah, we leave DNA all over the place, but people don't know that. But unless the court is going to impute that sort of knowledge and say that, so therefore, anywhere you go, you're just sort of deemed to know that you might leave your DNA there. Okay, well then, yes, just by virtue of going to the crime scene, you're knowing and intentionally, assuming the risk, I guess, of the possibility that your DNA will be left there. But most people don't know that. So, but that said, this is also just a general challenge for crime scene processing. If that reasoning is going to be accepted, it's good reasoning. It's a good argument. Mercy Wright, if Mercy's in the chat, I haven't been able to watch the chat, but Mercy made this argument on Twitter, X. I still can't make that switch, but it's a very good argument, because yes, if the premise is that all of this stuff is fair game because it's been abandoned at the scene, trace DNA, good argument, it hasn't been abandoned. But the problem is there's a lot of other evidence that police get at crime scenes that probably isn't intentionally hidden either. If you in a case like this, a stabbing type of case, very common for the perpetrator to cut themselves, leave their own blood at the scene. Are they doing that intentionally? No, probably not. Probably not. May not even know. Other types of things like that, footprints, again, latent fingerprints, stuff like that. Are they intentionally and knowingly leaving it at the scene? Probably not. Well, I wish you guys could see, there's like some horses walking by outside my window right now. Anyway, that distracted me for a minute. So she's got these ideas, I think, that are good, but she's not articulating them, I think, in a way that is connecting the dots really well. And now this Davis case she's talking about, I don't know the Davis case, haven't read the Davis case. Sounds like it has something to do with limitations on their ability to do subsequent testing. Spell this out for me, please, Anne, because it's really important. I need to not just hear that the Davis case exists, I need to know why it matters. And that's what the judge needs to know, is why it matters. Look at his body language right now. This hearing has like only just gotten started and he's already frustrated. And I kind of understand. Now, on the one hand, you might say, well, he's not letting her talk, so maybe she's getting there. Well, but he's really signaling to her what he wants her to talk about, and she's not doing that. She's kind of sidestepping the issue and walking around it a little bit. And so I suspect that if she were more directly getting to the point in response to his question, he wouldn't be interrupting her so much to be trying to redirect her. This is very normal, by the way, for an oral argument, for a judge to kind of interrupt. And frankly, I love it when they do this. I want to know what do you, the judge, what do you need to know to be able to make this decision? I would love to be able to give you that and just focus on that. My worst nightmare is the type of argument where you go in and the court has absolutely nothing to say, and I just have to kind of wing it and guess what's going to matter in their decision-making process, because I might guess wrong. They might not be on the same page as me. They may not get where I'm going. So anything that they're asking me, questions are help from the court. they're assisting you by asking questions. They're helping you focus on exactly what is the nature of the thing that they're having an issue with. So I don't see her handling that the way that he wants her to handle that. And I think that's why, we're seeing this body language here. She's not picking up what he's trying to pitch to her.
Those are the problems. As far as asserting family,
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath,
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose. And I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
cite to that.
I'm sorry.
Can you give me the cite to the Davis case?
Hang on. Give me 2 seconds. 2 seconds and glasses.
Now, this is definitely sounding really good, really on point. Blood validly obtained, but subsequent processing needs a warrant. Tell me more. Hammer on this case. Tell me the facts of this case.
Because my memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is 690 F 3rd 226.
Okay. I got a big old note on that.
Right.
Look that.
All right. And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a
So they did.
constitutional violation?
Your Honor, it goes to privacy.
Suppressed for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated as well.
This is the standing problem. We're back at the standing problem. It's not his DNA in the database. If it's not his DNA in the database, we're back at the standing problem. It's difficult because it feels like she is sort of deliberately avoiding that and like deliberately not addressing it, but you have to address it. I understand it's a weak point, and I understand that under the case law, it's probably fatal to your argument. If he follows the reasoning of all the other courts, and he probably will, you're not going to win that one on standing. I understand you got to still make it, but you have to be prepared to get over that piece. And so she's being circular here, and that's frustrating.
As well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy. So there's there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think
Oh man, it's squarely the way the question has to be looked at, Anne, and you know that. You know that. You know that. You know that standing is a problem here. You got to get past it, and I just don't think she has an argument to get past it. So that's really unfortunate.
The question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Mm-hmm. Yes, he's right.
Your Honor, we're
And she
here
knows.
because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Mm.
Well, you have a burden of showing that the items ought to be suppressed.
Yeah.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law, that's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case.
I don't understand that. Third-party doctrine versus getting in a cell phone. I don't understand that at all. I don't understand the argument. So third-party doctrine is a doctrine that Fourth Amendment case law basically deals with information that is held by third parties. And so they talked about this in the briefing. Jay Logsdon did the briefing on this, and he did a very good job, I thought, very kind of comprehensively outlined why there are incoherencies in the third-party doctrine today. And so traditionally, the idea was if a business collects information, has data, even if it kind of implicates your privacy interests, it's their data. So it's not your privacy problem. And that came up with things like utility records. I think they've used it for medical records sometimes. I forget exactly the details. But then as we kind of got into the communications era, they started to want to ratchet back on that. Oh my God, there's a little foal playing outside. Oh, how am I supposed to talk while this idyllic thing is happening outside my window? And so, especially as we've gotten into the cell phone era, they've really wanted to kind of ratchet back on that idea or just kind of not apply it in those contexts. Because the potential scope of the information that would be revealed is vast. And you can see that, for example, if you strictly apply this third-party doctrine to things like, I don't know, the Apple warrant, all of your cell phone data, everything that you've done online, Google, etc. It's Google's information. So just because it's your online activity history, profile, etc., they don't need a warrant. They can just go to Google and get it. Yeah, that's got big implications that the court doesn't want to go down. And so that problem hasn't really been reconciled in the case law. They've just basically had some situations where they say, yeah, we think the third party doctrine is going to apply here, so we'll let them do the search. And other situations where they said, nah, you know what, there's too much of a personal interest here, so we're not going to. And we don't really know where they're going to land on that. Is the issue with IGG a third party doctrine issue? No, it's not. The problem isn't the state's not arguing he doesn't have a privacy interest because this is information that GEDmatch, or whatever database they're using, it's the database's information. That would be a third-party doctrine argument. The state's arguing it's not his DNA, so he doesn't have standing. And I just don't see how Carpenter or Riley have anything to do with that.
There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Yeah.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial.
Yeah, but that's also a really critical point to the abandonment theory. I mean, he's saying you can't go to the crime scene, but the point is your DNA can end up at the crime scene without you being there. You didn't do it. Secondary transfer. Now we can get back into some of the comparisons with things like latent fingerprints and stuff like that. When you got items that are transferable, I mean, I still don't think there's really any case law that's going to support the idea that if you left, say, a fingerprint on an item that could have been transported to the crime scene without your knowledge, a drinking glass. You couldn't avoid it being at the crime scene by not going to the crime scene because you never went to the crime scene. So that can't be the test. I think that's got to be part of the argument here. If the point is that DNA is everywhere, your transfer DNA is everywhere, no, you can't prevent it from ending up at a crime scene by just not going to a crime scene.
I think the Carpenter case is really instructive for the court here, and that case was about third party with cell towers, and there was a concurring opinion in that case. I think that's instructive.
How is it instructive, Anne?
We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that. The tests are so different than they used to be now.
That's a great point. That's a great point. That the DNA, especially if you're talking about SNP profiles, they are much more analogous to the type of information that's available in your cell phone than the type of information that's available from a fingerprint, because it's not just limited to identification. That's a good argument.
It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches, and that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in public so it can be searched.
I understand now. This is making a little bit more. This is making a little bit more sense to me. This is why Anne is not dealing with the standing problem, because she's not focusing on the search of the IGG database. I mean, it was kind of raised, but the search of the IGG database is the one that implicates the interests of the people in the database, which is not, as the judge is pointing out, necessarily the same person as Bryan Kohberger. Can assert their rights. But she's arguing, no, what was obtained from the knife sheath needs a warrant. And she's doing that by comparing what was obtained from the knife sheath to what would be obtained from a cell phone. And yeah, you abandon a cell phone at the crime scene, still got to get a warrant to go in it.
That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case.
That isn't what it focused on. I mean, unless she's talking about a different case, that wasn't the key at all. It was a standing issue. It was squarely the privacy, the expectation of privacy in the shared components of the human DNA. It's like explicitly in the holding of that case that that's what they're addressing.
You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
Well,
So I
he's not
suspect
going
the state's gonna
to.
raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Or should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple of points on that. First, even assuming that that's all correct and that they violated the terms,
Seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other
But
people.
isn't there a subset that says, but I don't want these people to look at it?
Mhm.
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
And then they did.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's
Yeah, they can. You can limit. Of course you can. I can limit that my neighbor can come in my house and the police cannot. Of course I can. That's like the nature of having a privacy interest at all. Of course I can say police don't have the right to come and get it.
Against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service.
Got that, everybody? Did you hear that loud and clear? The government's position: if you use a database, you have given up all of your interest in keeping your genetic information private. I hope you heard that loud and clear before you consider submitting your DNA to any of these databases. That's the position the government's gonna take. Free for all. You put it in GEDmatch, you put it in 23andMe, you put it in Ancestry, whatever. Free for all. You have no right to restrict who can see it, what they can use it for. That's the government's position. Think long and hard about that.
Service, no one has a Fourth Amendment right to complain, and certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document, and if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say?
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, It expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath.
But nobody has any of those with respect to their DNA, period. Nobody has the ability, I mean, barring what, locking yourself at home, never communicating with anybody, never having contact with anybody or anything that might transfer your DNA in and out. It's not feasible. It's not feasible. This sort of property focused analysis of this issue is just it's not going to hold. It can't hold. It doesn't fit as an analogy when it comes to DNA because you don't have the power to control what happens to it the way you have the power to control what happens to your wallet or what happens to your cell phone or what happens to you know, things that are your property.
We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever, 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found, and they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who was engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information.
Yet. Yet. Yeah, how many months to years do you think it's going to take before they develop the medical information and use it and then argue that that's okay? Because you got this decision in this posture saying, no expectation of privacy in any of that. You abandoned it because it's at a crime scene.
And in fact, and I wrote this down when I asked what he would need to learn medical information from those SNPs, he said, quote, it would be a lot of research. So the defense is positing this question of, they're saying the court needs to ask itself.
This is alarming. Okay, it's not even like that would be technologically infeasible or we don't have the ability to do that. It would take a lot of research. So basically nothing but your willingness to invest the time and effort is keeping you from doing that. Combine this with AI. Combine this with AI that can do a lot of research in a very short period of time. Yeah, there's no longer any impediment to them doing that. This is so alarming.
What could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the US Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the US Supreme Court said, quote, even if non-coding alleles could provide some information, they are not in fact tested for that end. So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the US Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works.
I don't know that I agree with that, because typically there's nothing precluding you from being able to assert alternative positions. I mean, it's the state's burden to prove his DNA. He's not denying that there is some DNA on the knife sheath.
Your Honor, I also wanted to respond to an argument that was made in the reply brief, since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania.
Let's hear about
I'll
the
start
trash
by
pull.
saying the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that
Where were the garbage cans located in Pennsylvania? Were they in the curtilage? Have I been calling this from day one? I knew there was going to be a problem here. I knew there was going to be a problem here. That's why they had to put the disclaimer in the warrant, because they knew they didn't pull the trash off the street. They went up the driveway. They haven't said it, but they're telling me that that's what happened. They're telling me that's what happened. And they knew it, and that's why they had to do that disclaimer.
that maybe the officers went up onto the driveway instead of collecting them from the street.
Maybe they did. Did they do that?
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
pulled over after they got out of the neighborhood and said, here's what we got.
Well, I do believe it was prearranged with the FBI for them to do that. But
Are they talking about this case, or are they talking about the case law he's talking about? Prearranged with the FBI for the garbage collector to go into the driveway and get it? That's a curtilage problem.
my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear.
If that's the case, then I don't know why we're talking about I guess I'm confused. So if the FBI says the cans are at the end of the driveway, and that's established, that's not a curtilage problem. So I guess the defense argued they might have gone up the driveway. I don't know. I'm confused about where we're at factually now.
Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now it is what it is in this case, and we of course complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
Well, this is interesting. Did the FBI violate his rights? Why are we even opening this door? Why are we even having this conversation? If the FBI violated his rights, what did they do? And why won't Judge Hippler let us know?
That's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know,
Yes,
when you consider this, that that particular area had an ordinance, that trash had,
The court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case.
How does that change the analysis?
Well, Your Honor, I think that it changes
The
the
expectation of privacy is lost when you put it in the trash can to be taken away per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think that there is an expectation of privacy.
this is going to the issue of abandonment. Once again, we're going back to the knowing and intentional relinquishment. And so the idea is that if you are compelled to do it, it's not an abandonment. You're doing it because you have to. The whole deal with the trash is that the idea is that once you have finished drinking your soda or whatever, and you put the cup in the public trash can and you've walked away, you've recognized the possibility that anybody can come along and take that and do whatever they want with it. You've sort of given up all interest in and ability to be able to control what subsequently happens with that cup. And so that's where the abandonment of the trash issue comes in, as far as, yeah, you have an expectation of privacy in it, perhaps while it's in your hand. Once you throw it in the trash, now you've abandoned it. If your trash is in a place that compels you to do certain things with it. Does that mean, you're less able to, like, go back down and get it back out of the trash? Does it mean that the trash is now open to the open to the public? I mean, she's saying it has to be collected by specific trash collectors. That's a little bit of a different situation than, I'm at the movie theater and I just drop it in the trash can at the movie theater and go about my day. And it's also a different situation than I put it in my trash can at my house and I wheel my house down to my curb for, it's my day for my trash to be picked up or whatever, but it's going to sit there for 6-7 hours until the trash company gets there. And in the meantime, people are walking by on the sidewalk and people are driving by, and anybody and everybody can come in and go through my trash. If this is a different situation, then we need those details, and those details matter.
When you have to comply, you have to put your trash out in that particular manner. I
Unless you're saying the Supreme Court was wrong, that or Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything,
But I have to follow what they say.
but I have to make a record when I don't agree.
I appreciate
with
that. I'm
what's
just trying to
happened.
make sure we're talking about the same thing.
And I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do. So I'll move on to something else. I want to talk about now where Mr. Nice started, that Department of Justice interim policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like.
This is an interesting argument. It's a little bit of an odd one, I guess. But I sort of understand, I think, what she's getting at, and that's this idea. There's this case law. It's called the Aguilar-Spinelli test. That is typically dealing with anonymous confidential informants. Like if the state doesn't want to disclose who the informant is and their basis for relying on the informant and so forth, then they have to basically present information in their affidavit that establishes that the informant is reliable and that their information, they have reason to believe that the information is credible. And so that's kind of an interesting approach. A make them play by their own rules sort of standard. If the state is going to try to hide behind calling the IGG a tip and using it as a tip, then perhaps it needs to meet that standard. But then I think the problem that we run into is that they didn't rely on the IGG in these warrants. They relied on the results of the IGG in the warrants, but they didn't put anything in the warrant saying, we got this tip that there was going to be, genetic match. And so then we went and pulled the trash and so forth. They didn't rely on it. So it's very clever, but I don't think it's going to be quite on point here.
You would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you. All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally. Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
All right.
different things.
We'll take 5.
Thank you.
Back in.
All right, so they're going to recess now. And I guess I'll just skip this forward until they come back. So I think she's, you know, she's hitting on the sort of policy problem that this type of technology presents, but she really didn't address the state's argument that, be that as it may, that's not what they did in this case. So we can't, you know, find a violation based on what they could have done.
All right, let's take up Frank's.
Yes, let's.
Your Honor, I think on the court's bench, there was a document placed, so
What?
it had initials to
Oh,
comply
thank you.
with the court's.
Appreciate it.
All right, Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end,
13 areas.
We will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation.
Okay.
Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger.
So that's kind of important because that's certainly cutting against the implication that the search warrant affidavit and the probable cause affidavit in general was trying to present, right? They write this probable cause affidavit that makes it look like there was all this kind of ordinary detective work sleuthing happening, and that they had gone at it through the car, found the car, and then his was one of the cars, and then matched the bushy eyebrows, and in that description, and then they'd come across his prior traffic ticket from August, and use that to get his phone number, and then use his phone number to get his cell site records. They made it sound like this was all just kind of, normal sort of gumshoe detective work. And if Ann Taylor is correct, that's not what happened. They got the IGG. That told them, Bryan Kohberger, go back and look at him. And so then that's when they started doing all this other stuff to try to corroborate that his DNA being on that knife sheath meant he was the killer, he was there that night, etc. And that is kind of important because it affects the significance that you give that information, right? Particularly with stuff like the bushy eyebrows. I mean, really, nobody ever is going to be identified, or, it's going to be hard to exclude somebody on a bushy eyebrows type of description because that's so ambiguous. What does that even mean? I mean, I'm just going to say it again. Bryan Kohberger's eyebrows don't look particularly bushy to me. They just don't. They look like pretty normal eyebrows. So, yeah, just not sure that that in and of itself is like a material omission, but it certainly sets the stage for the fact that, yeah, the police were clearly trying to paint their investigation as something that it really wasn't, as occurring in a sequence and according to a logic that isn't what drove it.
He had not crossed their radar. That's nowhere in the affidavit. And that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI Same FBI that went behind and violated their own policy to try to identify somebody. They were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th.
So we're clearly talking about DM in this, the roommate, and yeah, the source of the bushy eyebrows herself.
2022, and she was sure. I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs.
Okay. She was sure that she heard these things. And so the PC affidavit said that she heard and saw things. Let's see where this goes.
That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated. It's
This should be-
repeated again in D8C as well.
This should be on
That
a
is
list.
important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers.
Okay, but are these things mutually exclusive? That she ran up and down the stairs and then went to bed and was murdered? Are we talking about at the same time? I need some more detail here.
Water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's 8C. And that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said.
That is definitely consistent with a trauma response. You see something that freaks you right the hell out. Yeah, you might not have a particularly good or clear memory of it. It might feel like a dream. In fact, that's a pretty common description when people are describing certain types of traumatic experiences, is it's kind of like being out of body, or it's kind of like being in a dream. So I certainly don't know if that's the case, but it's very much been my concern about the surviving roommates really from day one, because just by the nature of being surviving roommates to something horrific like this, is a pretty good probability that their memory wouldn't be reliable. We have this idea that you have like a better or a clearer memory, a more accurate memory of things that are traumatic because they would make such a strong impression on you. But that's really not the case, because you're forming these memories under such an extreme amount of stress. It's very often not the case. And then the problem is that it's the recall of the memory and the relating of the memory where the problems can occur. And so, recounting a memory is not like playing a video recording and you just watch it back and it's going to be the same thing every time. When you recall a memory, you are rewriting the memory. This is very well understood. Every time you do it, you're potentially incorporating new information that you've learned since then. You're incorporating, your new feelings about it. Just all kinds of things that happen with repetition of a memory, and that's why it's not that uncommon for memories to change over time, for stories to evolve, for things to grow. And it again doesn't mean that a person is necessarily trying to be dishonest or that they're deliberately lying. It's just how memory works. It's very, very infallible, very fallible process. So this should not be remotely surprising, that DM would have memory problems. I understand there's maybe some concerns about, were the roommates drunk, had they been partying, I mean, whatever. And can't say that didn't happen either. But even if none of it had, um, I would be concerned. I would be concerned about the reliability, not through any bad intention on any of their parts at all, but just because of the fact that that's how memory is when you're dealing with something traumatic. And I can't imagine really anything more traumatic than being witness to a crime like this.
Said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things. And the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Your Honor, the next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is. It's around this particular area.
Mm-hmm.
The next.
That is definitely, I think, a problem, in the sense that, the probable cause affidavit is predicated on the assumption that these are the same vehicle, that they are in fact able to trace it. And so If it's piecemeal, that in and of itself is kind of a problem because this car could, and then another car. How do you know? And so one possible way to be able to resolve that is because there's distinctive features or something like that, or at the very least, yeah, we've been able to identify these as the same car. And so like really, okay, maybe we can't say with 100% certainty, but what are the odds that, another exact same model and year car was, driving down this road at the same time? At least creates an inference. But if they don't really have any of that and they're just like, well, it's a white car, and then we traced around some other white cars, and at least one of those we were able to more specifically identify as, a some model year Hyundai Elantra, depending on when you ask. Yeah, kind of a little bit of a different picture there.
Next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car, where it appears again. It appears one time. And then what law enforcement did was they took several videos from all over the area and said, well, it's the same car and we have an identification.
So this, I agree, is a problem. If they're saying it's the same car, and they certainly present it in the probable cause affidavit as if it's the same car and as if they know that it's the same car, yeah, it probably is material how they reach that conclusion that it's the same car. Maybe.
That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop. And that's just not what happened. It's pieced together and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time. And they say this is when something was happening inside this house. We can hear this dog barking. And they use the videotape to get a time off that surveillance tape from the neighborhood, the 1112 King. And so they've got this time. But they also have this video, this trail that they've picked out a time that something probably happened here. And they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around the dog, had no blood on it whatsoever, but it was.
So assuming then that this means if the dog was crated, I'm sure she would be telling us explicitly the dog was in a crate, because that would explain why he wasn't tracking blood around and stuff. That's weird. That's definitely weird.
Was just sitting in an open room a day later. The magistrate is not informed about that either.
Okay, but I'm not sure what to make of that. I can certainly understand that that's weird, but what does that mean in terms of theory of the case? I don't know what to make of that. other than, God, I feel really bad for this dog too now.
Then then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge.
All right, so here's where I'm at with this. I mean, so far. Not sure we're in Frank's land yet, guys. Because, okay, I mean, yes, I think it's bad that they misrepresent the investigation trail, as she put it, but the probable cause determination isn't really based on the investigation trail. It's just based on the facts that were obtained. And so how they got those facts isn't really necessarily material to whether the facts themselves add up to probable cause. It's helpful context, certainly. And maybe we'd say it adds more context that would be helpful, but does that make the facts themselves misleading? I'm not sure that it does. I mean, frankly, from my perspective, this was always a really, really thin case for probable cause. It was always really thin, and that was pretty evident. So the omissions, false. I mean, it's not false that DM said she heard and saw things, right? That's not false. That's true. Omitting the specific things that she said she heard and saw, does that undermine the rest of the facts in the case? Is it exculpatory? Does it tend to prove Bryan Kohberger didn't do it? Not from what I've heard so far. It just changes the maybe theory of how this went down. But the affidavits don't say, they don't assert as a fact that, the victims were asleep in their beds when this happened. I think it's a theory of how it happened, but that's not like a fact that was asserted. And so if it happens some other way, that doesn't mean Bryan Kohberger didn't do it. Didn't disclose the memory problems. I don't know how that affects anything other than the bushy eyebrows. I really don't, because none of the description of how the crime allegedly occurred inculpates any particular person. It's not like without that, they couldn't still argue or still, rely on the trace DNA and the, videos and so forth to prove that it was Bryan, or to argue that it was Bryan. Now, I think the strongest ground that they're on here is the tracing of the car. And so, I mean, they're treating it as a given that it's all the same car, and it sounds like, okay, the defense certainly disputes that. But did they lie about it? Did they assert some basis for thinking that wasn't true? It doesn't really seem like it. Kinda. I'm not too sure about this, honestly. Maybe there's more. Same thing with whether the dog barked. This is weird. It's definitely weird how the dog was behaving, but it doesn't seem to have anything to do with Bryan Kohberger one way or the other. So let's see if there's more.
If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohberger.
This is an interesting argument. If they had known about the IGG, does that like bolster? I don't know that it adds anything to the final result that they already presented. They did the trash pull, they matched it to what was on the knife sheath. I don't know that it I mean, I guess it's cumulative is what he's getting at. The IGG pointed at Bryan, and so then that was corroborated.
Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was. So we just ignored that policy altogether.
I understand why this is kind of like outrageous to Anne, but the process doesn't really undermine the substance when it comes to the probable cause determination. It's just based on the facts, the totality of the facts and circumstances that are known at the time. So, okay, they have to put in the affidavit. Let's accept for purposes of argument that they would have to put in the affidavit that they, broke the database rules to get it. And the FBI did whatever it was that they did to be able to identify him as a potential suspect. I mean, disclosing how they did it is going to alert the defense team that you might have a motion to suppress that you need to bring here. But it doesn't undermine the probable cause.
I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that.
Okay, that's a good point. It's a good counter to his argument that the IGG would just add to it if it was included in the search warrant. But I'm not at the point yet of seeing that it undermines the rest of what was in the search warrant. I mean, credibility is kind of always at issue in a search warrant, but the reality is that, you know, the judge is not going to find, oh, I don't believe the cop. The cop isn't credible. They you know, they routinely do. And so even if they found like some specific aspect of it to not be credible, I don't think that that's going to taint the other, you know, unrelated facts that were included in the affidavit.
And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front. It wasn't to suggest it's otherwise connected to the homicide, except to say this is a car of interest, and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos, and that was testimony you heard today.
It was in the probable cause affidavit that one of the videos, and I don't remember which one it was, but on one of the videos, the car, you know, the white car that the state implied was the same car throughout, didn't have a front license plate. So if that is not the case and it's not shown on a video, now we have a pretty material misrepresentation, because that was key to narrowing the suspects to Mr. Kohberger, because he's from Pennsylvania and Pennsylvania doesn't require the front plate. So whole argument being it makes it more likely that this, you know, would be his car and not some unrelated car, because his car would be expected to not have a front plate.
You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff.
That to me seems pretty important, because that does go directly to the inferences that can be drawn against Bryan Kohberger. I don't like this being an afterthought. This is an important one. This is part of the direct link to why the state is saying it's him, and you can infer that it's him. If that's false, and you can't actually see that on the video, that's definitely a piece of the case against Bryan that falls apart.
That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So if, before the identification through IGG.
I'm just not tracking why that matters. But go ahead.
It matters because this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan Kohberger's phone. They do acknowledge that his phone wasn't contained within the geofence when they looked at the
His phone wasn't contained in the geofence. Ding, 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 ding. His phone wasn't in the geofence. Kind of important. If his phone was anything other than powered down, his phone would be in the geofence, because his phone can be in airplane mode and still be in the geofence. His phone, I mean, I guess he could have all of his location sharing stuff turned off. I'm not sure, though, that that would still keep him out of the geofence, because there's emergency services location stuff in your phone that I'm not 100% sure you can shut off. So rules out the option in the PC affidavit, right? They said there's a couple of options for why his phone wasn't connecting, right? Why they don't have him pinging. And the same type of thing applies. It's different. The ping is to the cell tower. The geofence, you're typically, it can include the cell site stuff, but you're typically talking now about GPS. You're talking about satellite-based location stuff. And the explanation in the PC affidavit for why his phone didn't ping is because it was powered off or put in airplane mode. Wouldn't be in airplane mode if he's not in the geofence. That can't be it. So it has to be the phone was powered off.
geofence. But the second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the car, the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off the network matters a whole lot in this circumstance. That's not corrected in any of the affidavits.
I'm willing to buy that the 7 minutes don't that the 7 minutes would matter, but I'm not seeing yet how the 7 minutes are material. If that affects where the car is then later supposed to be, you know, caught on camera and so forth, if that's like makes it infeasible for the car, like one of these videos to be the video of the car that the state alleges is the same car, that would make it material. But just in and of itself, it's a time discrepancy. I'm not seeing that it is material. I'm seeing it could be, but I'm not yet seeing that it is. And I would have liked to have a little bit better explanation for why the discrepancy between the 242 white car and the 244 is inconsistent with the car being at the intersection where it could turn either way. I didn't fully understand that either. That sounds like that could be important. If they're saying we saw a car on the video or something like that, and we saw it at 242, and then his ping isn't there until 244, and he doesn't, you know, ping there at 242, or, you know, GPS or whatever it is that they're using. Yeah, that makes it less likely that that's his car, so that would be material, and that would need to be disclosed. I'm going to have to go back, though, and look at the PC affidavit for myself to see that, which of course I can do and the judge can do, but you know, it's your job at the argument to make it easy. You're supposed to do that work for him. I wish she would have just told me. But I'll make a note here in my notes to go back and look at that.
That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in to create a false narrative for the magistrate to rely on to find probable cause.
So they chose not to do that is a little bit different than they knew and they omitted it. And I realize this is probably a distinction that, you know, only the lawyers are going to love that one. But it is kind of a distinction. If they stopped there, but did they falsify? Did they falsify the date it stopped reporting? Is the implication here that they did it and it undermined their theory because it showed he was going in the wrong direction, so they ignored it? Is that what's being implied here?
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town.
Mhm.
Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records, but based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there.
They put it in there to say he stalked them. And they used that specific language. We decided to look for evidence that Mr. Kohberger was stalking the home or something along those lines. And so we went and got all these records, and we found that his phone utilized cell resources that serviced the neighborhood. She's 100% right on that one. That's exactly what they did. That's exactly what they did. So if they knew he wasn't at or near the home and they omitted that, it undermines their argument he was stalking the house. So that would be misleading. That's a good point.
To make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side, but then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true.
You did.
This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that.
Kind of
We'll move
important to
forward
know.
the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again. And there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I thinking of a different date for the AT&T. I thought, not the cell tower stuff. Is that you still talking about the cell tower stuff?
no, I mean, that stuff applies to every single warrant we have because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in itself probable cause to support any of it?
Not when the state is specifically getting the judge to say, I'm not relying on this DNA for any aspect of probable cause because there might be a problem with it in case it gets suppressed. That's where the disclaimer becomes important. So the disclaimer certainly applies to those WSU searches. Did they include that disclaimer in other warrants? I don't remember off the top of my head. I really don't. But it would absolutely apply to the ones they did in Washington because it was in those. No, you can't rely on the direct DNA. You don't get to have it both ways. They specifically said, don't rely on it.
From there,
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the
what is
individuals.
that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context.
Spell
because
it
of
out.
The IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question.
Killed by a knife, it probably means a lot.
It might mean a
It
lot.
might.
Probable cause is not a proof beyond a reasonable doubt standard. It's
That is also
probable
true.
cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car.
Let's just go ahead and take this to the real life example, right? The Lucas Anderson case. It's one we always talk about with the transfer DNA. The judge is suggesting that the DNA in and of itself is going to establish probable cause. So the question would be, in the Lucas Anderson case, if when they had written that probable cause affidavit and said his DNA is found under the fingernails of the victim, you know, the murder victim, but they also included the fact, by the way, he was in the hospital that night at the time that these murders happened. He was witnessed there. It's in his medical records. He wasn't there at the scene. Do you still have probable cause now because of that DNA? No. It's a totality of the circumstances test. And so you can't just pull this one thing out in a vacuum and say, in and of itself, that means that there's probable cause. You have to take it in combination with all of the other evidence that's available. So that's a unique case, of course, because not very often you're going to have a rock solid, indisputable alibi like that. That pretty much makes it impossible that your DNA being present in that location has the significance that the state is attributing to it. But that's the point that I think Ann Taylor is trying to get at here. That it would be nice if she spelled out a little bit more specifically. For example, the car going the wrong direction and things like that. It's still not going to be as good as Lucas Anderson, because if his car is off, he doesn't have a rock solid alibi. Or not his car, but his phone. If his phone's off, he doesn't have a rock solid alibi. But if they can say, if she can undermine the rest of the remaining facts and circumstances, you're getting a lot closer. And I'm just, again, I'm talking about these other warrants, not the ones that specifically disclaimed the DNA. And then anything that relied on those warrants that specifically discounted the DNA.
In his apartment, as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. When a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon.
So basically, the judge's reasoning is even if the magistrate knew that Bryan Kohberger had never been to the house, never been anywhere near them, never known to have any sort of connection with them, no other trace evidence on him, in his stuff, at the scene, literally just trace DNA on a knife sheath, and his car was going the other direction and so forth. Is that in and of itself going to be probable cause? In that whole context, I mean, I don't know. Honestly, I really don't. I mean, I guess the cynic in me is going to say, the court's going to say yes, because probable cause is this very low standard. It's not proof beyond a reasonable doubt, et cetera, et cetera. It just requires a reasonable inference that's consistent with the criminal activity. But that's kind of scary, isn't it? You could have a lot of proof that you didn't commit the crime, but you got trace DNA somewhere, and that's enough for the police to come and look through your entire, digital history. Oh man, we really need better law on trace DNA. We really do.
I've not yet met a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence when there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out. that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I mean, I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have been
Unknown male what and blood. Okay, I'm gonna go
more
back
of a difference.
on
There's
that.
unknown male B in blood in the house attached to the handrail. The judge had been told there's unknown male B in blood.
Unknown male what and blood? I'm sorry, I might just be deaf at this point. Unknown male something and blood. Male B blood, B. Chat's telling me B. Type B blood. On the handrail.
Blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure.
The point is the significance of the DNA. He is saying in and of itself, the DNA has enough significance to establish probable cause. That's really what she's got to attack here, because the significance of the DNA just depends on the strength of the inference that you can draw from when and where and how it was found. And so that's why DNA that's found, sorry to get explicit here, but found like in a vaginal vault associated with the seminal fluid, that's pretty significant evidence because that gives you information about how it came to be there. And the problem with trace DNA is that you don't have that. You don't have the ability to establish how it got there. So that's why the surrounding circumstantial evidence is so important. So if that surrounding circumstantial evidence is strongly indicative of exoneration, then that significantly undermines the importance of that DNA on the knife sheath.
Not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
okay. I don't think probable cause is in a vacuum.
Yes.
I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up
Oh
blood
boy.
DNA of an unknown individual that was found, I think, on that handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here?
Yeah, I mean, I agree with that. I agree with both of these points. No, it doesn't automatically exclude him, but it's pretty important circumstantial information because the state's theory hasn't accounted for it. They haven't done anything that we've heard with this information. It's unknown male B blood. If that's an accomplice, what sort of steps were taken to evaluate that possibility? That's pretty important.
I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't
It's crazy to me. Sorry to interrupt this in the middle, but it's crazy to me that he's bringing up could be completely unrelated to the murders when we're talking about blood. You know, talking about unrelated to the murders. How about trace DNA? This is wild.
given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't.
Male blood D. Now it sounds like we're not blood type, we're samples. Unknown male blood D on the glove. Unknown male blood D.
Wasn't given a chance to ask any of those questions. She didn't know that Bryan's car, and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only.
The significance of the DNA on the knife sheath is what matters. DNA is not a smoking gun. If it doesn't matter that there's blood in the house, how could it matter that there's trace DNA on a knife sheath?
The only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr.
Trace.
Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But
It's
I'm not sure
trace
that that diminishes
DNA.
the probable cause as to Mr.
It's
Kohberger,
trace
if his DNA is
DNA.
found on a knife she found on or near the victim, who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that question, I think you can have
Not the
DNA
sheath, the
on an
DNA.
object at a scene when you know about all of these other things and you don't find probable cause because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Bryan's car, in Bryan's apartment, that there's no other DNA in there other than unknown male B that we know of for sure, and unknown male D outside. There is a lot of context there. And
If there's unknown male blood D, like sample D, then that suggests that there's also unknown male blood A and C. Does it imply that? It kind of seems to imply that to me, but I could be wrong.
all of a sudden, this one thing, the question of how is that there is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially
Yes.
when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause.
No connection with their social media accounts. Let's say that a little bit louder again, because that's just another one that, we already knew that from the hearing on the jury on moving the change of venue, that was false. Proof of stalking was false. But no, he wasn't following them on social media. Oh, this body language from the judge, man. Look at that. This is not where you want to be at this point in your argument. It's really not where you want to be at this point in your argument.
Don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, and they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important?
It would only imply that if it was in the search warrants that they were looking for that. And they didn't put in their search warrants, oh, and by the way, we went and swabbed his entire car and took apart the brake and took apart the key fob to look for victim blood and DNA. And then silence. Yeah, that would potentially imply that they didn't find it. But just not saying anything at all about it, no, it doesn't.
And as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think necessarily, that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
I think now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of them.
All right, go ahead.
Gonna attempt to.
Not great so far. I don't think they're going to get it so far.
As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. as the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case.
Just pausing to say I could do without the clutching of the pearls here. We know that. Let's not pretend law enforcement never lies. Let's not pretend it's so outrageous to suggest they might do such a thing. But I doubt we're going to get that.
And the state submits the defendant has failed to back up this claim. And they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A,
That's an interesting hypothetical. Did he choose that deliberately? Or is it really just hypothetically it was the cast expert who lied in the exhibit? She seemed to establish in her presentation and did that, yeah, probably the cast person, maybe, because that was the change in the time for when the phone stopped reporting to the network. Because if they reported the actual time and looked at the handoffs, the transfers, it would show his direction was not in the way that they were alleging his direction of travel was. So it kind of sounds like he didn't randomly choose this hypothetical and he's buying in that, yeah, the cast expert probably materially lied. What do I do with that?
would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if
And so her excuse is that they can use all of the facts in the Exhibit A, but only if the person, and all of those facts are sourced to all of these different law enforcement officers, and they only need to be signed off on by the detective, the one who is applying for the warrant, because they have the fellow officer rule, right? The knowledge of all of the other officers is imputed to the one that's asking for the search warrant. But when that goes the other way around, and one of those officers and that information, they have knowledge that it's false, that doesn't get imputed to the detective, seems to be her argument. I don't see that being right.
The person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate.
I'll concede I think there's an issue there, but
Good.
that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed.
Yeah, but it cuts both ways. You don't get to impute only the good knowledge and not the bad knowledge.
As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations.
Whether they conducted a joint investigation has absolutely nothing to do with whether there should be a Franks hearing. So I'm hoping that in the interest of fairness, we'll start to see maybe some repetition of the body language from Judge Hippler, maybe some of the helping to guide her with where she really should be arguing, because nobody's saying there needs to be a Franks hearing because they had a group investigation. It's about the knowledge being imputed or not.
Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding cast. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the Keene Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the cast work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, S.A. Balance's own experience.
If Balance lied, it matters. And I'm pretty sure she already just conceded that. She said, yes, we'd have a problem.
And then the law enforcement officer then states, from information provided by CAST, I was able To make determination, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is correct.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed their Frank's motion,
What specifically?
that there are 3 towers.
I believe
Remember,
I
we're
referenced
at
it in my
proffers.
response.
Yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I've been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's
Oh my Lord. So even the number of towers is in dispute?
what is in evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant.
So she didn't identify him. I would say that's pretty important when you relied on her bushy eyebrows to say that it's him. That is kind of important.
Well, it's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit?
Great question. Why were these ones even included? What do they have to do with PC? The bushy eyebrows, I understand why that one was included. But the rest of the statements about thought she heard something and the person said something, what was the relevance of that? I'm interested in this
as to
answer.
probable cause?
I cited those in my response throughout. She was,
What were they?
okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? So it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates.
So that kind of gets undermined when you're saying that's Bryan Kohberger, when she looks at a photo of Bryan Kohberger and says, I can't say that's him.
Corroborates when we know these crimes occurred. Yes, a general description is material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white, She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements.
So when the PC affidavit is reporting that she's saying heard playing with the dog, heard something being said, etc., did Miss Jennings just tell me that DM was texting those things to somebody as they were happening? And why would she be doing that if they were just things she didn't know that they were, significant for any reason? Because the PC affidavit certainly wasn't suggesting DM knew her roommates were being murdered and was giving a blow by blow. But if that isn't what happened, then why would any of that stuff be significant enough for her to be texting about it?
Not being included in the probable cause affidavit. You can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real. And we
no, they didn't know that what she saw was real or not real because they weren't there, Ms. Jennings. So they don't know. The attitude really needs to go.
know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification.
I just want to say I'm really pleased to see the mimicking the same body language here now again from Judge Hippler, because that's really called for. That's really called for here. Yes. Thank you for that, Judge.
Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene.
Do some quick math in my head there, because that doesn't seem quite right to me. That seems like 0.3 miles. The car is going, oh, let's give it the benefit of the doubt and saying it's going 20 miles an hour in a residential neighborhood. 60 miles an hour is 1 mile a minute. 20 is 3 times that. It would be 1 mile. Look at that, in 3 minutes. This is only 0.3 miles. 3 times too long.
They say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
So additional information. Additional information that they had that wasn't submitted with the warrant.
It was submitted through my response that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about route of travel and their differing opinions.
Defendant speculation about the route of travel, that's pretty rich. That's pretty rich.
On it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or sufficient proffer for you to do that. Next, the briefing addresses the IGG issue.
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that well, I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through, describe each and every still image or video to the magistrate. No, nor did we need to. Really, as discussed extensively, I think the only real Franks issue is, should the IGG process, the fact that it was not included in the PC, is that the basis for a Franks hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IGG and the use of IGG is only inculpatory. And the non-reliance on the IGG information does not diminish probable cause. And the IGG information was confirmed through the STR testing. I can't wrap my head around any argument that IGG and STR testing would be exculpatory.
Kind of with her on that one.
Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take out all information related to the dog.
Doesn't it kind of go to time frame to some extent, if nothing else? And how does that line up with the rest of the stuff and DM texting and all these other things that are going on? Doesn't it go to that?
It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing. Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation.
So I guess they learned something different. Is that what I'm getting? It's true. I mean, that's the standard. The affidavit is based on what you knew at the time. And turns out later that you were wrong. That doesn't undermine the Frank's affidavit, or that doesn't undermine the affidavit. That doesn't require Frank's hearing because you didn't know it was wrong at the time. And that will happen a lot with things like, you know, informants that lie, like that's never happened, right? But you don't necessarily know that at the time. You find out after the fact.
Defendant's opinions about where the shoe print should have been located, and it couldn't necessarily have been located there. Again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of this shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information.
So it sounds like they were able to ID the shoe print to a known person. Maybe an investigator.
I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Before you get to that, can you address the allegation that the cell phone data was, I guess,
purposefully erroneous as to the time that the phone was no longer reporting?
which then relates to the supposed uh, position of travel.
Right. Well, I still, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by the
Correct, the
cast member?
information that he was given from.
This goes to my
SMS.
first question about imputed erroneous statements.
Mm-hmm.
So I
Imputed.
understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's
If
material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of
Mhm.
travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. I mean, this assumption assumes that cars can't change direction of travel.
But you're the one that created the proposed path of travel that you submitted in your affidavits. So you're the ones that made that assumption, and you're the ones that seem to want the court to not question that assumption.
Assuming that then the same cell phone, which was then turned off, isn't then also tied
Turned
to
off.
the evidence, where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not.
Well, because you undertook to represent to the court how you think he got there. And having done that, if you knew he did not and could not have gone that way, you didn't have to do it in the first place, but you did. And so you misrepresented it. That's the problem.
It's a leap for me. Does that answer?
Well, it's your answer, so.
Let's say it was. Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included.
Yes, let's say that.
It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately.
It's definitely exculpatory. It's just, is it harmless? That's the point he's been making. You have the DNA on the knife sheath anyway. I just feel like I don't know. I feel like both of these attorneys have really kind of missed the ball today. I kind of feel like mimicking this same body language.
6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court
That's a yawn. That was like hiding a yawn.
believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Whew.
Briefly.
I'll try.
Try to do my part to make you, so that you can and avoid asking questions unless I'm truly stumped.
Before I get started on what I want to tell you, in response to what the state said and then my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good because it occurred after my Franks briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used the returns from the grand jury subpoenas. It used the return from the grand jury subpoena to obtain information. And we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. And that's kind of gotten to be
Amazon.
Sorry?
Is that Amazon?
It is Amazon, Your Honor. And the return on the search warrant says that they already produced them pursuant to something else. And the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have a Franks hearing to explore what that really is about, if for
That's
nothing
the
else.
omission or the misstatement that as it relates to the Amazon warrant.
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process. But for some reason, we need to come and get a warrant because nobody gets. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
I mean, I guess from a Frank's perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
It's not a Franks issue.
Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
disclose to the magistrate that this was the result of information given as a result of a federal grand jury?
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to just go ahead.
Okay.
They both know it's not a Frank's issue.
I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once, she said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it, like half this stuff. I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle is identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion? And
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
How much of the remaining 6 minutes are we going to spend thumbing through the papers?
Your Honor, I believe it's on page 17 of the amended memorandum.
Okay, not too bad.
That's just the photograph,
Yes.
but not the information that ties that to the Ridge Road camera.
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Oh, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet.
He's rubbing his eyes because it still doesn't really matter.
That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting, and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off, or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did, so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too, to leave just a little out here, to add a little more here, and go get a warrant, and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
All right, we will adjourn for today. I will take the Frank's motion related to IGG under advisement. I will take the Frank's proffer under advisement, issue opinions on those forthwith. We will pick up tomorrow with, I'm trying to think, we're probably at the evidence on the motions to suppress tomorrow, correct? All right, I'll see you in the morning.
All right. Well, I don't know, guys. I see it's gotten dark over here. Sorry about that. Well, so far, I don't think they're getting the Franks. And that's just mainly because I don't think they ever really addressed they kind of did, but just not sufficiently. Judge Hippler's point that if they have the DNA on the knife sheath, isn't that in and of itself PC? I think she kind of talked around it, but I don't think that she gave him a convincing explanation. I agree with her explanation, to the extent that that she gave it. The point is that the significance of the trace DNA, it can't be determined in a vacuum. The surrounding circumstances are what tell you whether that's significant or not. But he's also making the point that PC is not a particularly high standard. I don't think it gets him around the Whitman County warrants with the specific disclaimer in it, and any other warrants that had the specific disclaimer in it. She didn't raise it, but that's still a problem, I think. I'm kind of alarmed that they didn't raise that. I'm not quite sure what to make of some of this new information that we heard in this hearing. Guess we know it wasn't Bryan Kohberger that put his DNA in the database. Sounds like they're pretty much acknowledging that the FBI did, in fact, violate their policy as far as what they accessed. They accessed databases that they weren't supposed to have access to. I just, I think it's interesting to learn how this vehicle identification was done, because that definitely does sound weak. That sounds like it's going to be full of holes at trial that they're going to have a lot of opportunities to poke in, and then particularly if they are going to be able to compound that with problems with the direction of travel and so forth from the CSLI data. I don't think that's really going to help the state either. All this stuff from DM. She said things that weren't true and couldn't be true. Is she saying that the running up and down the stairs could not have been true? And if so, why do they know that that could not have been true? The dog stuff disturbs me. I don't even like to think about that. Dog is just in the room and it hasn't tracked any blood and it barked for half an hour. I really, really, really don't like that. I really don't like that. Dogs are very sensitive. But it does, yeah. Wouldn't that create some kind of issues with time frame? How does the dog barking relate to the 13 minutes when the car is there on the video? Unknown male DNA, D. Unknown male blood, D. Unknown male blood, D, which implies unknown male blood, A through C. On the handrail in the house. Not Bryan's. Okay, yes, I agree. Doesn't rule out an accomplice, but it certainly doesn't prove BK did it with an accomplice. It doesn't prove that at all. We have more, reaffirmation now, no contact, no DNA, no blood in the car, nothing like that. Took apart the brake, took apart the key fob. That's the type of thing you would do. Yes, that's a search. You are going down to the frame. You are taking things apart because blood seeps. It seeps into cracks. And that's how they're able to find it. It's virtually impossible to clean something like a car entirely. I think the most significant things, really the changing of the time when the phone stopped reporting, that seems significant, because the question would be, why would you do that if you didn't know that there was a problem with the true information? If you just didn't look at the directionality of the travel, that's a little hard to believe. That's a little bit hard to believe. So I think I'm willing to infer, and it sounds like the judge is willing to infer, that Balance was misleading in the cast report, because he knew that the true information was undermining the path of travel that the state was asserting. But I think that the state also made a point. Does it matter? Does it really matter? I mean, it does when you took it on yourself to say, but had you never taken it on yourself to say, does it make a difference one way or the other? I don't know. I mean, it's consistent. It sounds like it's going to be consistent with Bryan Kohberger's report of where he went and what he was doing, and not, consistent with going to King Road, but it doesn't sound like it excludes going to King Road. But just one more thing that when it gets to a trial context, I think it's just one more piece that the state had, and now it seems like it is falling apart. They don't have that anymore. The inconsistency between the 242 and the 244. That kind of seems like a problem. Again, if they're identifying a specific car as being his, but his location doesn't show up there until a later time. Especially if most of these videos, if there's only one that you can ID the car, how are we even saying it's the same car and not just cherry picking, white sedans? I'm going to be very curious to see all of this at trial. I'm going to be very curious to see all of this at trial, because I think it's gonna matter. What you can see with your own eyes. The FBI guy, he doesn't have magical eyes. He's not going to be able to see things that other people can't see. Now, he's trained, at least in theory, to be able to identify certain features of the vehicles and stuff that most lay people aren't, going to be in a position to be able to identify those things. But he doesn't have magic eyes. So if we can't see those things for ourselves on these photographs, then it's going to be a pretty tough sell that they're following the same white car and not just potentially cherry picking ones, especially if the data doesn't line up. The thing about the stalking being misleading, that definitely sounds like that's a problem. If they're presenting, they were presenting the cast data specifically for the purpose of saying we wanted to, evaluate whether he stalked the victims. We wanted to investigate that. And then we found he used the resources at the tower. That is super misleading when they didn't say we found that he used the resources at the tower, but he was never near the house and he never stopped at the house. That's definitely misleading. Take out the stalking. So my takeaway from all of this is that, yeah, case just keeps getting weaker and weaker. More of these hearings that we have. I don't think they're going to get the Franks. I don't think they're going to get the Franks because, again, I think he's just going to say, knife sheath DNA, standing alone, that's enough. Probable cause standard is very low. And it doesn't matter if that particular piece of evidence is potentially consistent with innocence. It can be potentially consistent with innocence and still constitute probable cause. So I don't think they'll get the Franks, but this is just not doing a whole lot here to add any confidence that I have in the state's case here. This is just not normally how investigations go, guys. It's not normally how they go when you start off with a thin PC affidavit and then you get your treasure trove of evidence after the arrest. And the direction of the investigation under those types of circumstances, you expect your case to get much stronger because when your facts are correct, there's usually multiple layers of things that will tend to corroborate it. An example for that I'll keep using, go and look at the Lisk probable cause affidavit. I really need to do a video on that one of these days because when you have layer upon layer upon layer, he's in that location, his phone pings there, he's emailing about going there, he's clocking in at work there, his DNA is on a cup that's found there, like, thing upon thing upon thing upon thing corroborates it. That's a much stronger case in the kind of way that you expect the investigation to unfold. But when they start looking and they find less and less and less, and then in fact they start looking and they find that their original information is not correct, yeah, it's not the way it's supposed to go. So that's my main takeaway from this hearing, guys. Let's go ahead and take a look at some of the questions and chats. We've got Phil, the Gilbert Biggs. The Gilbert Villain Biggs is now a YouTube member. Welcome, Phil. Appreciate you being part of the crew. Lisa Shelton, love and have missed you so much. I seriously set an alarm today to catch this live. Oh, it's good to have you here, Lisa. I missed you guys too, and I hope that your alarm didn't force you to be up 2 hours early because of my plane issues. But glad you were able to make it here with us. Emily, outstanding review on the Delphi motions. Thank you. Well, thank you, Emily. I appreciate that. Yeah, that's a tough one. That's a really tough one. But I'm very much looking forward to the appeal and seeing what they raise on the appeal. Because one thing I didn't mention in that video that I probably should have was just to clarify that the appeal is not limited to what they raised in this motion, right? The appeal can and almost certainly will include a whole host of other things that they raised at trial. But the purpose of the motion is basically just to be able to add to that list that they already have of things that they already raised to the judge, already got her to rule on, so that they have, more that they can argue on appeal. Hella mad. Nice editing. I like that. Hella mad, excited utterance. Hi, Andrea. Why during this hearing does Ann Taylor not refer to the DNA as transfer DNA? Surely the wording distinction would make a big difference. It might. I probably would, or trace DNA. I don't think that they can necessarily say it's transfer. It's certainly possibly transfer. I don't think it can be excluded as being transfer. but it certainly traced DNA. And I think, yes, you raise the possibility that it could be transfer DNA. That's the whole point. That's the whole reason why the significance is so important. If it's transfer DNA, then it's not indicative of guilt. And how do you know if it's transfer DNA or not? Well, one way to know that is how well corroborated is the inference of guilt. If the DNA is there because he committed the murders, how well is that corroborated? It doesn't sound like it really is very well at all. Larissa Harris is a new member. Welcome, Larissa. And Frank Smith, also a new member. Welcome, guys. James Casatelli, they should bring Joe Kenda out of retirement and start over on this one. Do I know who Joe Kenda is? Do I know who Joe Kenda is? Is he a TV? Is he a TV guy? I can't remember. I know the name rings a bell, but sorry, I'm not catching that. Not catching that reference off the top of my head. But I definitely agree that this is very disappointing from a standpoint of wanting some kind of answers. You know, it's just not a satisfying case at all. This is extremely, extremely thin. What's this? Michael Corey. This won't come up and stay. Mike K, another defense attorney here, screaming Trace. Yes, Trace. Trace. Trace matters, guys. That's the importance of it. I think that's a very interesting question, is can trace DNA standing alone be probable cause? Now, you have to pardon me sometimes when we get into this Fourth Amendment stuff, because Washington has such a strong independent constitutional jurisprudence that we sort of have our own rules, and the Fourth Amendment doesn't really matter. And so I don't always know the ins and outs of a lot of the details of the Fourth Amendment stuff. It's just it hasn't been relevant to my particular line of practice. But the reason I bring this up is because in Washington, we do have case law that for something to constitute probable cause, it does have to tip the scale towards criminality. And so if there's a piece of evidence that has equal inferential value, that's potentially exculpatory, potentially inculpatory, you don't get to rely on that for probable cause. I had this in a case where I was challenging a search of a backpack, and so one of the bases for it is kind of a long, convoluted series of events where a car got seized, and because the bottom line was that they knew the people, right? They knew the people. And one of the guys was like a known frequent flyer. That wasn't the client. My client was a passenger, but they knew one of the guys. Well, having a criminal history is equally, it's you can be minding your own business, not committing crimes with a criminal history. In fact, probably the overwhelming majority of the time, that is in fact what you're doing. So having a criminal history alone doesn't tilt the scale in favor of guilt. Knew that he had drug history and stuff like that. What they see in the car is an Altoids tin, and that's what they want to look at. That's what's leading them to think, well, there's probably drugs here in this car. We want to search through this car. Well, it's very much the case that sometimes Altoids tins just have Altoids in them. And fortunately for me, I got the detective to admit that on cross-examination, because that ended up being featured in the opinion. The fact that Altoids tins do sometimes contain Altoids. So that doesn't tilt the scale in favor of probable cause. because of all this, if you don't have one thing that tilts the scale, you just have, these inferences that are all consistent with innocence. You don't have probable cause. So that's the standard that we use in Washington. Assuming, which isn't always a good assumption, that that's the same standard that they would use for the Fourth Amendment. I think it's a very interesting question about trace DNA, whether trace DNA is necessarily going to establish an inference that it was there because of the commission of the crime. And I mean, there's just not a lot of study on this. There should be, but our forensic scientists here in the United States don't have a real particular interest or incentive to pursue a lot of studies about trace DNA. So what is being done is being done overseas. I've seen a lot of stuff coming out of Australia, but I think that's important and an interesting question. It's a very significant legal issue that's really underdeveloped. All right, guys. Well, not too late, right? We didn't do a 9-hour live stream today. This is perfectly reasonable and not at all over long. So I do want to appreciate you guys all joining me and all the nice comments and everything that people sent while I was away for quite some time. It's like I said, it's been like 2 months, I think, since I made a video. I'm not gonna lie, Delphi did. It took a lot out of me. It took a lot out of me to do that. I got home, I got super sick. I got sicker than I've been in a long time. Just this respiratory infection that absolutely knocked me down, and I couldn't get better from it. I kind of wondered at some point if I had pneumonia, because I just had no energy, and I would if I would feel better and then I would go do something and like work in the yard or go to the gym or whatever, and it would like overexert myself. And then, knock me back and I'd have to go like sleep for a couple days. So anyway, I dealt with all that. And then of course it was the holidays and that's always chaotic and getting through that. And now I'm down in Chile. Now I'm down in the southernmost city in the world and getting ready for a very exciting hiking trip here. I'll just mention again, if any of you are interested in sort of my travels, I tend to put most of that up on Instagram. I drop things in my stories and doing a few more posts and things like that of places that I've been going to. So just having a good time and happy to share that with you folks that are interested. So, but it is good to be back, and I am feeling a lot more just re-energized and kind of remotivated to be back in the driver's seat, back in the YouTube mix with some of these trials coming up. So thank you all for joining me. I look forward to hopefully seeing a lot of you again tomorrow, and we'll go ahead and watch an evidentiary hearing. Boy, that sounds like that's going to be juicy, guys. That sounds like there's going to be some more stuff. So can't wait to see what they got. All right, everybody. Thanks again. Have a wonderful evening. Sleep well, and I will see you guys tomorrow.